matter of Houssein and others, and London Credit Limited and others.
Mr. Cowan,
Good morning, my lords.
have you, between yourselves, sorted out what order things are going to happen in?
We think we have, subject obviously to the court's approval. What we are proposing is that my learned friend, Mr. Hutton, and I, who appear for the appellants on our appeal, will deal with our appeal, grounds 1, 2 and 3.
Yes.
Then Mr. Wheeler, King's Counsel, who appears for the respondent, will respond to our appeal and open his appeal,
Yes.
his cross appeal. We will then respond to his response and deal with his cross appeal. He will then finish off by responding to any points that we've raised in relation to the cross appeal.
Yes.
That's our proposed batting order, as it were, but we're very much in the court's hands if the court would prefer us to do it some other way.
Subject to anything else I'm told, that seems absolutely fine to me. Have you managed to work out roughly how the time allocations work as well?
We've not discussed that, no. I suspect strongly that grounds 2 and 3 may take longer than ground 1 in our appeal. Ground 1 is a relatively short point of construction, as you will have seen. Grounds 2 and 3, I think my learned friend Mr. Hutton is going to have to go into some more of the factual background and a little bit more of the detail as to what happened at trial.
Yes.
In terms of the cross appeal, again, likely to be longer, I suspect, than ground 1 of my appeal, but perhaps not as long as grounds 2 and 3.
Well, I probably shouldn't say you up any more at this stage. Perhaps at lunchtime you could review between yourselves where we've got to and how the remaining days should be used.
Yes. So, my lords, as I've mentioned, my learned friend Mr. Hutton, King's Counsel, and I appear for the appellants together with Mr. Blakeney. Mr. Wheeler, King's Counsel, appears for the respondents. Mr. Blakeney is the only one of the 4 of us who had the pleasure of appearing below. There are... I'm sure he necessarily thinks it was that much of a pleasure, but there are 2 appeals before your lordships. Our appeal is 3 grounds. Ground 1 is the short point of construction in relation to the facility letter relating to the extent of interest payable following the repayment date, and grounds 2 and 3 are costs. And then on 15th of April of this year, your lordship gave permission to the respondent to cross appeal relating to an issue concerning whether the default rate of interest sought under the facility letter amounted to a penalty at common law. Your lordship should, I hope, have the core bundle, supplemental bundles, 2 authorities bundles, and skeletons from both sides.
3, actually.
Yes, there were 2. They multiplied to 3. I'm not sure it's changed anything of substance, but at least presentationally we're into 3 volumes.
Thank you. Lord, the judge in his initial judgment gave a very detailed factual background to the case which you will no doubt have seen, and therefore it's my intention to provide you with a relatively short and brief overview of the facts. My learned friend Mr. Hutton, when he comes to address you in relation to grounds 2 and 3, will supplement what I'm saying in relation to those parts of the factual background which go to the question of costs. Ground 1 is a question of construction of facility letter dated the 20th of July 2020, by which the 3rd appellant was lent the sum of £1.881 million for a period of 12 months by the first respondent. The facility letter itself was varied by a deed of variation dated the 31st of July 2020, but nothing particularly turns on that document. It did nothing material other than to vary the sum which was to be advanced. The monies were lent secured on various assets belonging to the first appellant and her then husband, Ali Houssein, who sadly passed away in December of 2020. The second appellant is their son, Houssein Ali Houssein, who brings this claim in his capacity as executor for his late father. In particular, first legal charges were taken over 5 buy-to-let properties owned by a combination of the first appellant and Ali Houssein. And a first legal charge was also taken over their private residential home at 71 Hamilton Road in Barnet.
That was the home of Mrs. and Mr. Houssein, deceased.
Correct. The respondent also took a debenture over the assets of the third appellant company, and also took personal guarantees from both the first respondent, Mrs. Houssein, and her late husband, Ali Houssein. The lending was for 12 months. It was not conventional bank lending. It was bridging finance for a short period, designed to allow the Housseins time to arrange more conventional lending. So the standard interest rate payable and provided for in the facility letter was £1% per calendar month, with interest compounded at monthly rests. And in the event of a default, or in the event that monies were not paid back at the end of the 12-month period, the facility letter also provided for a default rate of interest, which was 4% per calendar month, also compounded monthly, which is the equivalent of an annual interest rate of 60.1% when the compounding is taken into account. By way of comparison, the Bank of England base lending rate at the time of the facility letter was 0.5%. And as is often the case with this type of bridging finance, the standard interest for the whole of the loan was rolled up and added to the sum loaned. So there are no monthly payments for the borrower to make, because the interest is effectively paid at the date of drawdown by the grant of the loan. All the borrower must do is repay the loan at the end of the loan period. This was unregulated lending, and as a result of that, it was a condition of the loan that Mr. and Mrs. Houssein did not reside or occupy any of the properties as their residence. As I've already mentioned, 71 Hamilton Road was their private residential address and their home. They occupied it as their home throughout. And you will have seen from the judge's judgment that Mr. Leondaris, who was the broker who arranged the finance with the first respondent, and the first respondent's business development manager, Mr. Stylianides, took staged photographs of the property at a meeting at the property to make it look as if the Housseins were not living there, when in fact they were aware that they were living there.
And this led the judge to conclude that the non-residence requirement had been waived.
My lady, that's right. And it followed from that there was no breach, and it followed from that
Well, no, event of default.
sorry, there was no event of default, and it followed from that they were not entitled to appoint the receivers that were appointed, and I'll come on to that in a moment. Mr. Leondaris and Mr. Stylianides, having attended this meeting at which these photographs were taken, then lied about it in their evidence, and then lied about it in court on oath. So the facility monies were then released to the third respondent on the 7th of August of 2020, but a very short time later, by the 8th of September of that year, the first respondent was already alleging that the third appellant was in breach of the facility letter by reason of the residential occupation by the Housseins of 71 Hamilton Road. So they claimed at that time to be entitled to default interest of 4% per calendar month, compounded monthly. The appellants did not pay those sums by way of interest. And on the 3rd of November of 2020, the first respondent demanded repayment of the total sum loaned, together with default interest. And the first respondent then appointed the second respondent as receivers over 71 Hamilton Road and subsequently over the 5 buy-to-let properties. The second respondents played no part in the trial, play no part in this appeal. My learned friend, Mr. Wheeler, represents only the first respondent. Then on the 29th of April of 2021, the appellants brought this claim. They claimed 5 remedies. Firstly, they said there had been no breach of the facility letter and no event of default had arisen because the first respondent was well aware of the Hussein's occupation of 71 Hamilton Road and that they must be therefore taken to have waived that breach. Second, they said that the default rate of interest was unenforceable as a penalty at common law. Third, they said it followed from the waiver that the first respondent's appointment of the receivers was unlawful. Fourthly, that the facility letter itself was unenforceable against Mrs. Houssein on the grounds of undue influence. And fifthly, that the facility letter was unenforceable on the grounds that it was a sham or pursuant to various claims made under the Consumer Credit Act 1974 or the Consumer Rights Act 2015. And the matter was heard over 6 days by the learned judge, who gave a lengthy and detailed judgment on the 12th of June of 2023, which is at tab 9.1 of the core bundle. The judge held, as you will have seen from his judgment, that the first respondents' representatives had known that the Husseins were in occupation of 71 Hamilton Road and that they intended to remain in occupation. He found that both Mr. Stylianides and Mr. Leondaris were dishonest in their evidence to the court about the inspection of the property, and he found that they took photographs designed to mislead concerning the Hussein's occupation of that property. And he held, therefore, that there was no breach of the facility letter because there had been a waiver, so therefore there was no default interest due, and the appointment of the receivers was unlawful. And he also found that the default rate of 4% per month, compounded monthly, was a penalty at common law and therefore unenforceable. The appellant's claims based on undue influence and sham and the consumer credit claims were dismissed. And there was then a further hearing to deal with consequential matters, which took place in September of 2023. And at that hearing, the issue arose as to what interest, if any, was payable by the appellants from the repayment date, which is the 7th of August of 2021, onwards. Part of the, as you will have seen, part of the sum which was loaned had been repaid, but only £1.2 million of the sum had been repaid. And so there was a significant chunk of the sum still outstanding as at the repayment date of the 7th of August 2021. So the question, one of the questions raised on the consequentials hearing was, well, what level of interest is payable on that sum going forward? And that is the subject of ground one of this appeal. The first respondent at that time also sought permission to bring a counterclaim in the event that the appellants are successful on their appeal. The counterclaim seeks statutory or equitable interest on the sums due from the 7th of August 2021. And although I needn't take you to it now, the draft of that counterclaim is in the supplemental bundle at tab 14, and there is a draft defence for that counterclaim at tab 15 of the supplemental bundle. And at the consequentials hearing, the judge on the construction issue held that interest was payable from the 7th of August 2021 at the standard rate, the 1% per calendar month compounded. And for that reason, he felt that he didn't need to make any order on the proposed counterclaim. So if your lordships allow my appeal on ground 1, the matter will in any event have to then be remitted back to the court to determine whether or not the counterclaim should proceed. Well, that's all I wanted to say, I think, by way of factual background at this stage. As I've mentioned, my learned friend, Mr. Hutton, will doubtless want to add more detail to those bare bones as he makes his submissions in relation to grounds 2 and 3. Lords, ground 1 on which I seek to address you now is essentially a short ground of question of construction. The principles of contractual construction and the authorities which establish them are well known and are common ground between the parties. You will have seen that we have set out in our skeleton at paragraph 28 some passages from a 2021 decision of this court, EMFC Loan Syndications and the Resort Group, which I don't intend to take you to now unless you particularly want to look at it. It merely summarises the relatively well-known position and the relatively well-known authorities on that point. Can I begin then by taking you to the relevant document to be construed, which is the facility letter, and it's at tab 1 of the supplementary bundle. And the court below heard that this was the standard form of facility letter for the first respondent.
I'm sorry, could you just give the bundle page number again?
Yes, so it's the supplementary bundle, tab 1, and it starts at SB3.
Thank you.
Number. And can I just invite you to look briefly, please, at the definition of finance documents on page 1, which is internal page 1, page SB3. Finance documents means the facility letter, the security documents, and any other document designated as such by the lender. So the definition of finance documents includes this facility letter. And then over the page on SB4, towards the top, you have a definition of interest period, which means in relation to the loan 1 calendar month. And then interest underneath that, immediately underneath that, interest rate means the rate of interest referred to at clause 6.1. Then if you turn over to SB5, the repayment date means 12 months from the drawdown date. And then if I can ask you to turn over, please, to SB9, we come to clause 6, which is the main provision dealing with interest. I need to take you through this, I think, in a little bit more detail. And what we say essentially is that clause 6 provides for interest rates to apply in 2 different sets of circumstances.
Before you get to 6, though, 5.1.
Sorry, my lady, yes, you're quite right to have pointed that out to me, and in fact it's in my note. I'm not quite sure why I skipped over it, but 5.1, you're quite right. Interest due on the loan should be paid together with the loan amount, all of the sums due under the finance documents, and that's why I took you to the definition of finance documents, in full by no later than 12 noon on the repayment date. And then this sentence that was discussed at trial below, but I don't think need detain us terribly much longer. The facility should be cancelled in full on the repayment date. I think that simply means that if the money has not already been repaid by the repayment date, it's to be repaid on the repayment date. And then we come to clause 6. And first, clause 6.1 provides that the borrower should pay interest on the amount outstanding under the facility as from the drawdown date at a rate of 1% per month. It provides that that is a discounted rate, although at trial and indeed since trial it's not clear from what that figure was said to be discounted or for what purpose. And then the final sentence confirms that it's calculated on the basis of a year of 365 days and accrues on a daily basis. I'll come back in a moment, if I may, to 6.2. Can I skip over to 6.3? 6.3 provides that the full amount of interest which is payable under the facility letter is payable on the drawdown date, and the sum drawn down therefore includes the interest which is notionally paid in advance to the lender. And as I said before, this is absolutely standard for this type of bridging finance. It means that there are no monthly payments because all of the interest which accrues under the facility has been paid as soon as the money is drawn down. And the amount to be repaid at the end of the facility includes all of the interest to be charged. And then can I skip over, for the time being, 6.4 and 6.5 and take you to 6.6? And 6.6 provides for a different rate of interest. The clause is headed default interest. And that provides that upon the occurrence of an event of default and I invite you to highlight those words, and or if the borrower fails to repay any amount payable by it under any finance document on its due date, interest shall accrue on the overdue amount from the date from the due date up to the date of actual payment, the standard rate being 3% per month above the interest rate. That's defined as the default rate. So the interest rate was 1% per month. 3% per month above that is 4%, and that's where the 4% per month comes from. Can I then go back, as I said I would, to 6.2, which relates to interest periods? And 6.2 provides that the first interest period for the loan shall commence on the drawdown date, and for each interest period thereafter, the last day of the preceding interest period. And 6.5, I apologise for skipping around, but there is, I hope, some logic to this. 6.5 provides simply that if an interest period would end on a day which is not a business day, then it's either the day after, if that's within the same month, or the day before, if it's not within the same month. Then 6.4, an interest period shall not extend beyond the repayment date. I'll come back to that again in a moment. And 6.62, default interest that is accrued under this facility letter shall be due and payable on the last day of each interest payment. Will accrue daily on the balance outstanding on the facility, and shall, to the extent not paid on the last day of each interest period, be compounded, and shall itself bear interest at the default rate. So the purpose the appellant submits of those submissions, of those provisions, is to establish a due date for default interest in a situation where default interest falls due before the end of the 12-month period of the loan. So there's no due date for standard interest payments, as we've already seen, because there's no need for one. They're all due at the date of drawdown and added to the sum loaned. But where there is a default before the end of the 12-month period, the default interest has not been paid already. So clauses 6.2, 6.4, 6.5 and 6.62 fix the date on which default interest is payable at that time. So if, for instance, you default in the 3rd month of the 12-month period and you default on the 6th day of the month, what these provisions do is to fix the date upon which your default interest becomes due as the last date of that month.
But all those other provisions will have been relevant to determining how much the amount of the standard interest was, which was added in to the amount at the start.
My lady, yes. Yes.
That's the calculation.
Yes, it all goes into the mix to determine what the standard rate of interest is at the beginning.
So those provisions are relevant in relation to standard interest as well.
Yes, they are relevant to the extent that they bear upon the amount that would be charged by way of standard interest, yes.
So the one that would be different is 6.62.
Yeah.
Yes. Yes. Once the 12-month period has passed, and if there are still monies outstanding as at the repayment date, then there is no need to have a due date for default interest to be payable. It's simply due on each day that passes until such time as is actually paid. So we say that the relevance of the interest periods, the monthly interest periods, is only in relation to default interest and only in relation to default interest within the 12-month period of the loan.
And why draw a distinction between the 12-month period and what happens afterwards in relation to default interest?
Because by the time you get to the point where the repayment date has arrived and you're supposed to have paid back all the money, then either you've paid back all the money by that date, in which case it's irrelevant, or the money is simply due every day. And so you don't need to calculate a date on which default interest falls due for those purposes. It's simply due every day that passes.
So just so I understand, so post repayment date, you don't need to have a structure for working out dates. But if that's right, why do you need it in relation to default interest before the repayment date?
Well, I see the point that your lordship is making, and it may be that there's some force in it, but the question is, what does this mean? And one is trying to attach some significance to it in the light of the other provisions, and in particular in the light of 12.5 that we'll come on to look at in a moment.
So why do you say in simple terms, why do you say 6.62 does not apply after the expiry of the 12-month period? What is it that it is in the drafting of what we've read so far that leads you to that conclusion?
Largely 6.4, because what 6.62 is concerned with is default interest which is accrued, and it provides for that to be paid on the last day of each interest period. But 6.4 tells us that an interest period shall not extend beyond the repayment date. So the whole concept of paying on the repayment date appears, as a result of those provisions, to apply only to a default pre the repayment date. Now, I completely take on board my lord's point, which is, well, why would you have that? It's not particularly, it's not especially necessary. To which my answer is, I don't know, is the answer, but it's there, and that seems to be why it's there and what it does, we say.
And so you say 6.6 little 2 only operates if there is an event of default before the
Yes.
term date, let's
Yes.
the repayment date,
Yes.
and doesn't operate thereafter.
Yes. My lady, yes.
But that interpretation rests on 6.4, does it?
It's certainly supported by 6.4. Yes, I think it does rest on 6.4 because interest periods don't extend beyond the repayment date, and 6.62 is
Really?
the purpose of 6.62 is not to create an obligation to pay. That's created by 6.61. 6.62 is simply there to clarify when that obligation falls due, so that the borrower knows when he's in default, that if he's in default on the 3rd of October, that he doesn't have to pay the default interest until the last day of that month. But we're told, for whatever reason, that an interest period shall not extend beyond the repayment date, and therefore that's why we say 6.62 doesn't extend beyond the repayment date.
So interest periods are only relevant for the assessment calculation of default interest prior to the repayment date.
That's our case, yes.
And you say, therefore, that afterwards, 6.6 little 1 is the operative paragraph.
Correct.
It's puzzling as to why it's all drafted in this way.
Well, it's not a, with all due respect to the draftsman, a terribly happily drafted document in several
Otherwise you
respects.
wouldn't be here, would you?
Well, I think that may be true.
None of you would be. But I mean, it's all dotted about. It should be.
It is all.
It should be on your interpretation. It should be. Well, I could cut and paste.
Well, your lordship makes the observation that it's all dotted about. We haven't even got to clause 12.5 yet, which is even more dotted about in the sense that it's not
not
even,
in 6.
Not even within 6. It's somewhere completely different within the document.
So does that mean that on failure to pay on the term date, on the repayment date, means under 6.6 little 1 that default interest is due,
Yes.
but that it's not compounded? Why should it be compounded? Because if little 2 only relates to within the period, if there's an event of default before the repayment date,
Yes.
and so you've kind of struck a line through that,
Yes.
Mr. Cowan. We've only got little 1, and little 1 says applies in event of default and or fails to repay, and then tells us what the standard that the rate will be. Sorry, I'm probably missing something.
Well, my lady, I see the point. I'm not sure. I can see the argument. I'm not sure I necessarily, and I appreciate this is a point against me, but I'm not sure I necessarily agree with it. I think 662 is still relevant to the extent that it refers to default interest that has accrued under this facility letter being compounded and bearing interest at the default rate.
So you keep
So you don't strike a line
most
through.
of the clause.
And my lady, even if that's wrong, you get the compounding in any event in 12.5, which we haven't looked at yet.
Yeah.
But at SB 18, at 12.5, the clause finishes by saying interest shall be compounded on a monthly basis in these circumstances.
Okay.
So even if I'm wrong about that, that's where the compounding comes in. Can I then invite you to look at clause 12, which starts at SB 16. And it's headed events of default. And I would invite you to look first at clause 12.1, So upon the occurrence of any of the events in 12.2, the lender may, by notice in writing, demand immediate repayment of the loan together with all interest, fees and commissions. Thereupon the borrower shall forthwith repay the same and the availability of the facility shall terminate. And 12.2a is if the borrower fails to pay any sum due to the lender on the due date.
And the due date is the date that immediate repayment has been demanded.
Yes. Then one turns to clause 12.5, which is at SB 18. And this provides for any monies falling due for repayment by the borrower pursuant to this facility letter for the time being unpaid shall bear interest at the rate specified in clause 6.1 or 6.6 if applicable, calculated on a day-to-day basis from the date of so becoming due until the date on which payment is received. Interest shall be compounded on a monthly basis in these circumstances. And the learned judge found this was a freestanding obligation to pay to pay interest. The appellants submit that all that this provision does is to repeat the provisions of clause 6, and that it doesn't create a separate right to claim interest.
Is that compatible with your submission a moment ago that the last part does create a right to compound?
Yes, I think it's compatible with my submission, provided my submission in relation to in relation to 6.6 1 and 2 is correct.
What is your submission about the compounding of interest under 6.61 and 2?
Well, that 6.62, that notwithstanding that it applies only in relation to a default during the term of the loan, in other words, a default before the repayment date, that notwithstanding that interest which is accrued can be compounded on a monthly basis.
Why do you say that?
Well, my lord, I say that because notwithstanding that we say that 6.62, that those parts of 6.62 which relate to interest periods relate only to the position pre-repayment date, that's C 6.4, that notwithstanding that 6.6 2 does provide for default interest accruing under this facility letter, paid on those dates, and shall be compounded and shall itself bear interest at the default rate.
Well, I wonder whether actually you have to say that the last sentence of 12.5 is a charging provision on your case. Suppose it isn't. Where do you get compounding on a monthly basis on your case?
Well, Lord, from, I say, 6.62.
Monthly basis isn't mentioned. It says compounded.
Yes.
I mean, you can sort of get monthly compounding there in relation to interest periods, but you say there isn't an interest period after the repayment date.
Yes, because of 6.4.
Which I follow. But on that basis, you don't get from 6.62 monthly compounding, do you, post-repayment date?
Well, my lord, I see the force in what your lordship is saying. My submission is that you could read 6.62 as allowing compounding. If I'm wrong,
compounding weekly or yearly.
Yes, well, it doesn't specifically talk about. Yes, I mean that would be the same you could argue the same thing in relation to 6.62 in relation to pre-repayment date in any event.
But doesn't that omission emphasise that 6.62 is only intended to apply prior to repayment date, not thereafter?
Well, yes, it may well do. It may
Which
well
is
do.
fine for your case if you can say that 12.5, the last sentence, is a charging provision, so to speak. But nevertheless, first part isn't.
Well, what I say in relation to 12.5, as I've already said, is that it simply repeats what has gone before. And it is part of my grounds of appeal, as you will have seen, that clause 12.5, we say, is not a separate freestanding provision. And I'll come on to the reasons for that in a moment.
Yeah.
But we do say that even if we're wrong about that, the question of construction can still be decided in our favour. And if the question of construction is still decided in our favour, then we succeed on ground one in any event. So in other words, the supplementary point that we make, which is that the judge, in deciding that 12.5 was a separate freestanding right to interest, got it wrong, is not, we say, determinative of ground one of our appeal. Our primary case is that it's not a freestanding right to interest, but if we're wrong about that, then we say that ground one should succeed in any event.
I mean, on my way you put your case is, well, look, we can see, looking at clause 6, that the applicable bit of clause 6 in these circumstances is clause 6.6. It all turns on whether clause 6.6 is enforceable. If it's a penalty, it's not enforceable in that sense.
Yes. My Lord, I think has my point. That, my Lord, that is the principal point, and that is the principal point of ground one of the appeal, which is this question of what does if applicable mean within clause 12.5. We say that the position is straightforward. The facility letter provides for two sets of circumstances in which two different rates of interest are payable under the terms of the facility letter. Only one of the two sets of circumstances is applicable at any given time. The parties know which set of circumstances applies, and therefore how much interest notionally is payable under the contract. The position, we say, is simply binary, depending on the facts. And what that also means is that the parties to the contract can predict with certainty which of the two rates of interest is applicable in any factual situation. Going back to clause 6.6, what 6.61 tells us is that upon the occurrence of an event of default and or if the borrower fails to repay any amount payable under any finance document on the due date, interest shall accrue on the overdue amount at the higher default rate of interest. It's mandatory. There's no choice for the parties. So in this case, the repayment date was reached and the whole of the monies borrowed had not been repaid. And that was an event of default under clause 12.1a of the agreement. So,
hang on. Is that an event of default?
yes, if the borrower fails to pay any sum due to the lender on the due date.
I'm lost. Where am I?
Oh, I'm so sorry, my lady.
No, it's my fault.
No,
and
no,
I'm just
I'm sure it's
wanting to be clear.
SB 16, 12.1
Yes.
and 12.2a, brackets A.
Yeah. Sorry. So that is an event of default.
Yes.
I was just looking back at the way it was said in 6.6, which seems to make a difference between event of default and amounts outstanding at the end, if you see what I mean.
Yes.
But 12.2a, Yeah.
And it doesn't really matter for my purposes which it is,
Yeah, I'm just-
whether it's an event of default or if the borrower, quotes, fails to repay any amount payable by it under any finance document on its due date, because we know from 5.1, which was the provision your ladyship pointed out to me, that everything is due as at the repayment date.
So really, on your case, or possibly any case, one could have omitted the words "and or" if the borrower fails to repay any amount payable by it under the finance document on its due date.
Yes.
Yeah.
So we say that as at the repayment date, the factual circumstances change from a situation in which the clause 6.1 rate, the standard rate, applies, to a different set of factual circumstances where the applicable rate of interest was that payable under 6.6. 6.1 was no longer applicable. Now we know that, subject to the cross appeal, the 4% per month default rate of interest was an unenforceable penalty as a matter of public policy at common law. But the fact that the 4% interest rate is unenforceable does not, we submit, alter the contractual position. We submit that the words applicable and enforceable are not interchangeable. They don't have the same meaning. Here we say the 4% rate is applicable because the contract provides that it applies in those circumstances. It merely cannot be enforced. And as we say in the skeleton, for something to be enforceable, it must be applicable, but not everything which is applicable is necessarily enforceable. And so we say that the judge fell into error at paragraph 9 of his judgment on the consequentials, which is at the core bundle at page 139, behind tab 9.2. where he says at paragraph 9 in the third line, clause 6.6 is never applicable because it is unenforceable as a penalty. That's the effect of the Macdessi decision at paragraph 9. Whether something that is unenforceable still exists as a matter of law is irrelevant to the operation of 12.5. If it is unenforceable, it cannot be applicable. We say there are two problems with the judge's interpretation that if something is unenforceable, it's no longer applicable. The first is that he's altering the sense of the word applicable as used in clause 12.5. In the context of the contract, the words if applicable, we say, have a particular meaning. That meaning is limited to the two sets of circumstances in clause 6.1 and clause 6.6 of the contract. That is why 12.5, we say, refers specifically to clause 6.1 or clause 6.6. What the judge has done, we say in error, has added a further gloss to that by looking at them outside the context of the contract. He says that because the 6.6 rate is unenforceable, it is inapplicable. But that widens, we say, the meaning of applicable to introduce facts and matters which are out with the contractual framework. And that brings in the second problem, because at the time that the contract is executed, on the judge's construction, it would be impossible for a party to know whether or not the rate under 6.1 is applicable or the rate under 6.6 is applicable. We've only reached that point after a year's litigation and a 6-day trial. So the enforceability, we say, of the 4% per month default rate is not something which would be within the knowledge of the parties at the time that they enter into the facility letter. The learned judge contended that it would be possible for the parties to know at the time of execution that the default interest provision amounted to an unenforceable penalty. But in my submission, he fell into error in that respect. Where there is a penalty, whilst it's correct that it is a penalty from the commencement of the contract, that will almost by definition not be within the knowledge of the parties at the time that the contract is entered into. If the lender knows that the 4% per month is a penalty, he's not going to enter into a contract which doesn't entitle him to get any interest in those circumstances. So there are those two difficulties, we say, with the judge's interpretation, and there is no such difficulty, we say, with our interpretation. It is either 1% or it is 4% in the event of a default. The parties know exactly where they are. So without wanting to repeat myself, we say merely because it's not enforceable doesn't mean it's not applicable. The judge held that because 6.6 was unenforceable, you were able therefore to fall back on 6.1, and that's what he did in awarding interest at the 1% per month rate. And we say he was in error in doing that because 12.5 doesn't on any view allow you to go back to 6.1 if 6.6 is, quotes, applicable, which we say it clearly was.
And another way of articulating your applicable enforceable point is to say that in 12.5 shall bear interest at the rate specified in 6.1 or 6.6 if applicable is in fact just looking to the circumstances in
Yes.
which those sub-clauses kick in.
Yes, indeed. And that's, in a way, why, notwithstanding what we have said in our grounds of appeal, that whether 12.5 is a separate provision, separate right, in a sense, doesn't matter that much. Because even if it is a separate right, the words, if applicable, if they have the meaning that I say they have, then I get home on my ground of appeal in my
They're a reference back
They're a reference back, indeed.
to the circumstances in which those clauses
So-
or sub-clauses apply.
Indeed. So even if it's a freestanding obligation, they are simply a reference back. So because we say the applicable rate is 4%, because that's unenforceable, it means that there is no contractual interest, we say, which is payable after the repayment date. The respondents get no interest for that period subject to their counterclaim. Now, that may sound harsh on the first respondent, but the court will have in mind that it is the respondent's default rate of interest which the court below found to be extravagant and or unconscionable, having regard to its commercial legitimate interest. So we submit it ill behoves the respondent now to complain about not being able to get a lesser sum when it's pitched its own default rate at a rate which a judge, considering the evidence, has found to be unconscionable.
Well, we'll come on to that, but
And
whether
we'll
the
come on to
judge
that.
used unconscionable or extortionist is another question.
No, well, we'll come on to that.
Can you give me some idea of what the financial consequences of this issue are in terms of, so I understand what's at issue at this point?
Well, there are
If that's
three possibilities. One, of course, is that my learned friend, Mr. Wheeler, succeeds on his penalty point.
yes,
If he succeeds on his penalty point, then this is all irrelevant anyway,
yes,
because ground one goes.
of course.
And if he succeeds on his penalty point, the interest is in the region of 1.7 million.
The interest.
The interest. Is that right? If you're against me in relation to this appeal and therefore the 1% remains, the figure is roughly £250,000. And if you're with me, obviously, in relation to this appeal, then the answer is nothing. We don't pay any
Subject to the
interest,
counterclaim.
subject to the counterclaim.
So sorry, 1.7 million.
Roughly 250,000 on 1%,
Yeah,
and
nothing on yours.
nothing subject to the counterclaim.
So just breaking that down a moment. To what date are we taking those figures?
That's to today's date. I can give you exact figures if you would like them, but
It's probably enough.
That's
For
enough.
no.
present
And what's the
purposes.
counterclaim?
Well, the counterclaim, we don't know how much the counterclaim is for because it's been brought on the basis of a claim for statutory interest or equitable interest, and we could work it out presumably based on the judgment rate of 8% per annum. I'm not sure whether anyone's done that. My learned junior reminds me the claim is for 12% per annum simple interest.
And do you have a ballpark figure for what that would entail?
I'm told 200,000.
So 12% simple interest, 200,000. As you say, I mean, the judgment rate hasn't changed much over the years.
No.
So that's 8% simple interest.
That 200,000 is based on 12%.
But if you were to get
if it was the judgment rate, it would simply be 8% simple interest.
and
So that would be 2/3 approximately of that figure, I imagine.
yes, I see. So getting that depends on the respondents being allowed to run the counterclaim. If they
we have various defences to the counterclaim, which you may or may not have
No,
looked
I haven't
at.
looked at them.
No.
I mean, on the face of it, you would think if there's a debt outstanding, normally you're entitled to statutory interest.
Subject to the defences that we've
Yes,
raised in
okay.
the counterclaim, which I won't take you to today.
No, okay.
Thank you, that's helpful. So if the respondent wins on the penalty point, 1.7 million.
Yes.
If the respondent loses on the penalty point and you lose on your appeal, if you win on your appeal and the respondent loses on the cross appeal, you get nothing. You pay nothing, subject to whatever
Correct.
happens on his counterclaim,
My lord, that's right.
which may be up to 200,000,
Yes.
between 1 and 200.
Yes. The only other point that I wanted to raise very quickly in relation to this is a point relating to this the supplementary question, if I can put it that way, of whether 12.5 is a freestanding obligation. The way in which it's put in Malone and Fremster Wheeler's skeleton argument is that it's a freestanding obligation because it performs a different function to clauses 6.1 and 6.6. And can I take you very briefly to his skeleton argument, which is at tab 4 in the core bundle. At page B61. So what Malone and Friend, I think, is doing here is at paragraph 29 of his skeleton is seeking to persuade you, your lordships, that clause 12.5 serves a different function to clause 6.6. As I've said, even if he's right about that, I don't think it matters. But just to make this one point good, at 29.3 on page B61, he says clause 6.6, and this is 5 lines from the end, clause 6.6 therefore makes provision for the payment of interest at the default rate only where early repayment of the loan is demanded following an event of default, such that there are overdue amounts that are payable prior to the repayment date. So he's making the same distinction that I was. And then he says clause 6.6 does not apply after the repayment date at all. And the very short point I make is that that ignores the wording of clause 6.6, which he's helpfully set out in that paragraph, and in particular the words and or. So it's upon the occurrence of an event of default, or if the borrower fails to repay any monies payable by it under any finance document on its due date. It's not just a situation where there's an event of default, albeit, as my lady has already observed, yes, it is rather circular, because one of the events of default is non-payment on a due date in any event.
But one doesn't get that until one gets into 12.
Into 12, yes. My lords, I think that's all I want to say in relation to ground 1.
Are you going to show us where precisely the judge went wrong?
Well, my lord, I think
You probably covered. You said what he went wrong. Where,
Yes.
where in the judgment do you say
in paragraph
actually went wrong?
in paragraph 9 of
It's that bit you already
yes
showed
that
us.
I've already indicated.
It's just that bit
because
of paragraph.
that's the bit really which is the key as far as we're concerned, because that's the bit where he says that where he deals specifically with the applicable enforceable point, which really
It's
lies
just
at
that.
the heart
It's
of
just that.
really lies
It's
at the
that
heart.
single sentence.
What about the paragraph 11, the judgment? I'm not sure it necessarily matters, but so he says, well, if it's not penal, he sort of says you get an election.
Yes.
Right? It's obviously an election that one would expect only to be exercised one way, since presumably the lender would always want to go for the
Yes.
higher rate.
Right. And clause 12.5 we say doesn't provide for an election in any event. It's not something where they have a choice. It's as we say, binary. Simply one set of circumstances applies or the other does.
You'll have to tell me what the McDessie decision is.
Well, that's the
Cavendish.
decision in relation to
The Cavendish.
Yes,
It's
Cavendish
Cavendish.
Square. All
Okay.
Yes.
I see. So that it doesn't help us on the interpretation. It's just because it's a penalty,
Yeah. Well,
or because it's
the point that he's referring to, paragraph 9 of McDessie, is making the point that the question of whether something is a penalty applies from the time that the document is entered into. It's not something that, as it were, it doesn't become a penalty later. It's either a penalty at the outset or it's not.
right. So why is he wrong to say that that's the effect of paragraph 9 of Cavendish decision?
Because in my submission it doesn't follow from. I can take your lordship to McDessie in a moment if you would like to look at it, but in my submission it doesn't follow from his point about it never being applicable because it's unenforceable as a penalty, simply because it is either a penalty at the outset or it's not. So in my submission, he's wrong about that as well, although it doesn't really make a difference to the decision that he made. The key point, the key error that he falls into in my submission is whether something that's unenforceable. If it's unenforceable, it cannot be applicable. That's the key point.
And your point about that is, penalty is always a penalty, but you've got to look at what the parties understood at
Yes.
the time they entered into the contract. And they
Yes.
didn't know it was a penalty, or else they wouldn't have entered into it.
Quite.
And what about paragraph 12? Finally, clause 12.5 does not seek to resuscitate something that's dead. It references 6.1 or
Yes.
6.6 because it in effect resuscitates them after the end of the term, is what he's saying.
Yes, I think
And
that
they
is
wouldn't
what he's
exist
saying.
afterwards. They wouldn't exist otherwise
Well, they-
after the end of the term,
yes.
is what he's saying.
Yes.
So what do you say about that? You've probably said it already. I'm sorry, Mr.
No,
Cameron.
no, my lady. I'm not sure I have. Let me just read it again to myself. Well, I think what he's dealing with here is partly the point about whether or not clause 12.5 creates a freestanding right to interest. So I think what he's saying is that rather than continuing the clauses after, I think, my lady, it's the point that your ladyship made earlier, that rather than continuing the clauses and simply adopting them, as it were, that all that's happening in 12.5 is that there's a reference back in 12.5 so that one knows what the two rates of interest payable under 12.5 are. Now, as I say, for the reasons that we've set out in our skeleton argument, we say that's wrong, but I also say that it perhaps doesn't matter that much if I'm right about the other point.
I'm not sure I have quite got it. So, according to the judge,
Sorry, my lord.
Mr. Blakeney was seeking to suggest that clause 12.5 sought to resuscitate a dead provision. Not quite sure what Mr. Blakeney would have meant if he had advanced such a submission.
I'm rushing to Mr. Blakeney's defence. Mr. Blakeney was led below as well, albeit not by myself. Can I just speak to him briefly? So I think it was to do with the obligation not going past the repayment date. So I think the argument was that 6.1 and 6.6 had effectively ceased to have any force because they only had force up to the time of the repayment date. And therefore and that's why he talks about referencing the rate referred to in 6.1 and 6.6 rather than seeking to continue clauses themselves after they have by their own terms come to an end. So I think what he's trying to do is to justify the idea that 12.5 is a separate freestanding right to interest.
I mean, I think I am getting myself muddled, but I would be very surprised if below it had been argued on your side that 6.6 was not capable of operating according to its terms after the repayment date.
No, I think your lordship is right. Let me just see if I can. We do have in the supplemental bundle
The skeletons.
skeletons. So tab 10. Oh, I'm told by my
This would be consequential.
They're only the trial skeletons, not the consequential skeletons.
Yes.
Well, my lord, maybe once I've spoken more to my learned junior, I can help your lordship with that point in greater detail in due course if it becomes important. Lord, unless I can assist further, those are my submissions in relation to ground 1.
Thank you very much, Mr. Cowan. Ms. Hudson.
My lords and my lady, the grounds 2 and 3 both relate to the judge's cost order at the end of the trial. Ground 2 being in relation to challenging his issue-based cost order, which was a pure issue-based costs order. We get the costs of the issues on which we won, they get the costs of the issues on which they won. And ground 3 challenges it on the basis that the order that was made was purely on the standard basis rather than any part of it being on the indemnity basis. My lords, in terms of where this appears, the judgment on costs appears in the same consequential judgment that you were just looking at in relation to the interest point at 9.2 of the core bundle, starting on page 140. And I'll come back to this, but it's a relatively brief judgment. Paragraphs 14 through to 20 are the judge's reasonings for the issue-based cost order. And then the order itself, if we can go to that, is at the previous tab, tab 8, at page 82. And there are the declarations made at paragraph 3. The declarations are: there was no event of default within the facility agreement. Little 1. Little 2, the first defendant has not been entitled to charge default interest. Little 3, the default interest rate is an unlawful penalty, it's unenforceable. Little 4, the first defendant's demand notice dated 3rd of November 2020 was wrong and without effect. And similarly, in relation to their demand to mortgagors in November 2020 and January 2021, they were wrong and without effect. And the appointment of the second defendants as receivers on those 2 dates, the first date related to the 71 Hamilton Road, which is where Mr. and Mrs. Houssein were living at the time. The second, in relation to the buy-to-let properties, were unlawful. The total amount due at little 7 was just short of £630,000, the repayment sum. And then we see the contractual interest payable in relation to 12.5. And then at little 9, by consent, the amount of interest on the repayment is that figure. Paragraph 4. Yes.
But the references to by consent are in effect that the maths has been agreed.
That's right, exactly. It was clearly argued at trial, but subsequently then, as a result of the judgment, yes. Yeah. So by consent might be a little misleading, but yes. So paragraph 4 is the appointment of the receivers. The second defendants was set aside. Then paragraph 5, permission in their application in relation to 3.8 of this order. There's no order on the said application, not quite sure what that was in relation to, but don't need to worry. Paragraph 6 is about amending their particulars of claim. Then at paragraph 7 was his cost order, 7 through to 13. At paragraph 7, the defendants must pay the claimant's costs in relation to the following issues. This is the purely issue-based cost order. Firstly, whether there was an event of default under the facility agreement and the consequential issues in relation to the demand notice and demands to the mortgagors and appointments of the second defendant. And secondly, whether the default rate under the facility agreement was an unlawful penalty, which is unenforceable. Paragraph 8 provided that no costs were recoverable in relation to the preparation of the witness statement of Houssein Ali Houssein, who was the son of Mr. and Mrs. Houssein, and was the second applicant, second claimant. And then paragraph 9 was the order that we pay the respondents' costs in relation to the list of issues there. Firstly, whether the terms of the facility agreement were unenforceable under FUSMA, if I can use that shortening, section 26(1). Secondly, whether the legal charge was not binding by virtue of section 62(1) of the Consumer Rights Act. Thirdly, whether the facility agreement was an agreement to which section 140A of the Consumer Credit Act related. Fourthly, whether the personal guarantee in relation to 4 properties listed there, including 71 Hamilton Road, should be set aside on the basis of undue influence. And fifthly, whether on true construction of the facility agreement, the first defendant was entitled to recover contractual interest. So the point.
So that's just all the things you lost on and all the things they lost.
Exactly, simple as that. No costs were recoverable, paragraph 7, in relation to the evidence of Mr. Leondaris and the evidence of Mr. Stylianides. And paragraph 11 said this: for the avoidance of all doubt, the foregoing orders for costs are intended to cover all issues in the proceedings, and any interim orders reserving costs or ordering costs in the case shall allocate costs accordingly. And they shall be, paragraph 12 is detailed assessment, and paragraph 13, he didn't make an order for payment on account because he couldn't tell who was going to be the net payer or the net payee.
I'd say that's quite surprising. I mean, even on his basis, it's surprising he couldn't work out where the balance lay.
Yes. Well, we say, with respect to the learned judge, that, and of course, I'll come on to the fact that we're appealing a cost order after a 6-day trial, and that provides a hurdle for our side, and I entirely acknowledge that. But we say that, in effect, the judge, to put it colloquially, copped out on the cost order. It was his task, we say, to evaluate who was overall the successful party in the light of what the litigation was really about, why it had come about, the offers that were made to settle the proceedings, which the effective offers all came from our side, and numerous of them were actually beaten by us. And instead he just defaulted to the path of least resistance, which was, well, you can have your cost of your issues and they can have their cost of their issues. And that, we say, has created an injustice on my clients. And we say that. Can I come firstly to the test that I have to face, and I acknowledge that test. This is an appeal from a costs order. I have to show that the judge erred as a matter of principle, or in exercising his discretion, he exceeded the generous ambit within which reasonable disagreement is possible, or he left out of account or took into account some feature that he should or should not have considered, and that his decision is wholly wrong because the court is forced to come to the conclusion that he has not balanced the various factors in the scale. Can I just take your lordships and your ladyship to two authorities on this? It may be, of course, it's trite law that you'll be very familiar with, but just it's helpful to see how it's been put in the Court of Appeal previously. So hopefully you have the authorities bundle, which I don't think we've looked at yet, and tab 4, so that should be in your first authorities bundle. And it's the decision of Birchall and Bullard of this court in 2005, and it's paragraph 25 of that, the judgment of Lord Justice Ward. And at paragraph 25, Lord Justice Ward says this: appeals against orders for costs are notoriously difficult to sustain. That is because the trial judge has a wide discretion, with the result that this court will only interfere with his decision if he has exceeded the generous ambit within which there is usually much room for reasonable disagreement, or because, even more unusually, he has erred in principle. This point is firmly taken by Mr. Counsel for the respondents, and I bear it well in mind. Can I also just deal with a case that my own friend has relied on. It's at tab 15. I'm not quite sure which bundle that will be in. Is that section? It's the case of Capelli and Circetti. In 2018, the judgment of Lord Justice Hickenbottom. And it starts at paragraph 5. Having recited the rule that deals with costs at first instance, 44.2 at paragraph 4, paragraph 5, then Lord Justice Hickenbottom says this: it is in relation to that rule, several points worthy of note. In considering orders of cost, the court is of course bound to pursue the overriding objective as set out in CPR 1.1, i.e. it must make an order that deals justly with the issue of costs as between the parties. Therefore, when considering to make a cost order, and if so, which the order it makes, the court has to make an evaluative judgment as to where justice lies on the facts and the circumstances as it found them to be. Pausing there, we say that is one instance where the judge has simply gone wrong. He hasn't made that evaluative assessment of where justice lies, and we say that the purely issue-based cost order is not just in the circumstances, which I'll come to obviously. Secondly, before an appeal court will interfere with the exercise of that discretion, as with any appeal, it must be satisfied that the decision of the lower court was wrong or unjust because of a serious irregularity in the proceedings below, and 52.21.3. No one suggests that there was a serious irregularity in this case, and we don't suggest that here. It is unfortunate that the judge made an issue-based cost order without having canvassed it with the parties at all in argument, and neither party had sought an issue-based cost order or even mentioned it in their submissions. Now, I don't say that's a serious irregularity, but I do say that it should have been canvassed, ideally, and parties should have been able to make submissions on it before the judge simply said, that's my decision.
But so how do you place that? You say you're not saying there's an irregularity, but you are relying on this. But where does that get you?
Well, I mean, I say the judge went wrong in the way that he dealt with it.
Is that you're saying, therefore, it's not surprising that he got it wrong because he didn't ask us?
Yes, I am saying that. I'm saying that he ought to have raised it with the parties and sought submissions on it. He may have come to the same decision, but he didn't do that.
I think what as my Lord Justice Baker is saying, I'm just trying to tease out, are you saying there is an irregularity or not?
I suppose, my lady, strictly, I probably am saying there is an irregularity.
Okay.
I mean, the word serious, no doubt, lead you to hesitate.
Exactly.
But your case is that he didn't ask, he didn't tell us he was going to do it. He didn't ask for our submissions on it.
No.
He should have done.
Yes.
That's an irregularity. And as a result, there was an injustice.
Yes, that is my case, exactly. And then little 3, before an appeal court concludes that the cost decision below was wrong, it must be persuaded the judge erred in principle, the other factors that we mentioned, or that the exercise of his discretion was wholly wrong. And little 4, an appeal court will only rarely find that the exercise of discretion below is wholly wrong, because not only is that discretion particularly wide, but the judge below is uniquely well placed to make the required assessment, having heard the relevant evidence. So that I think deals with the hurdle that we have to face.
And you're going to come back to some of the other stuff in this judgment.
Yes, I will. Yes, exactly. Because as your lordship will have seen, there's more redlining of that decision. Yes. We say that the issue-based cost order, if I can deal with that first in isolation, does not reflect the context in which this litigation came about. And that context is that it came about because of the first respondents, LCL's claim, that there had been an event of default, namely that 71 Hamilton Road was being occupied and lived in by Mr. and Mrs. Houssein. And as we'll come to, they issue a notice of default and then a demand notice on the basis that they are entitled to proceed, and they do proceed, to appoint receivers in order to sell the properties on the basis of the event of default. And so Mr. and Mrs. Houssein, who were both living there at the time that those notices were received, unfortunately Mr. Houssein died shortly afterwards, had their home threatened. And that is what this litigation was really fundamentally all about, was them saving their home. And the judge's issue-based costs order simply doesn't reflect the fact that that was the context in which the litigation came about, and in which they were, on those points, wholly successful. Because they weren't in default. It wasn't an event of default, on the judge's findings, because the first respondent was aware and had waived the requirement that there be non-residents of 71 Hamilton Road. And secondly, that they weren't entitled to default interest as a result of a default. And those things, upon which my client were wholly successful, was the reason the litigation came about in the first place. Now, I have to accept that as part of the litigation, my client then ran other arguments on top of those, and we'll come to those. But they've been referred to in the costs order and reflect the issues that the respondents have recovered on.
And they ran those arguments and failed on them.
And they failed on them, absolutely. And that inevitably is going to have some effect on the costs order, and I don't seek to dissuade you otherwise. But the context in which the litigation came about, and the fact that Mrs. Houssein ultimately was vindicated in terms of saving her home, is highly relevant, we say, as to what the litigation concerned and what was central.
So you really lost on undue influence and the statutory claims.
Yes, and sham, which was closely related to the statutory
Yes.
claims.
And the undue influence claim would only have affected the Mrs. Houssein.
Yes.
So on that basis, the lender would still have had all his remedies against
Mr. and the estate. Yes. Yes.
And the properties, or which properties were in her name, or
Yes, and his check. 3 were in her name and the others were in their joint names. So there were 5 in total. 6 in total, sorry, 71 Hamilton Road and 5 other properties.
So 3 in her name and
3 joint.
3 in joint names.
That's right. So 3 in her name, 2 purely in his name, and 71 Hamilton Road was joined.
But the undue influence went to the charges over those properties,
Yes.
and went to her personal guarantee,
Yes, that's right. Yes.
which was in relation to the lot.
Which was in relation to the lot.
and so far as the jointly owned property is concerned, if the undue influence claim had succeeded, I assume the lender would still have had rights over Mr. Hussein's interest in it,
Yes.
but not a legal right. It would be an equitable right, I suppose.
Yes. Yes.
Yeah.
So we say that the purely issue-based cost order doesn't reflect the justice of why the litigation came about. And the reality is, of course, is that we never would have run those arguments if they hadn't claimed an event of default in the first place. I don't think there's any, there's no evidence about it, but it must follow. There was no suggestion that the Husseins were going to challenge in some way the first respondent in relation to payment of the principal sum. they were happily living in the house, having had this facility letter which enabled them to do so. And it was only because an event of default was claimed, the house became threatened, and litigation became necessary. On our case, it was necessary in order to defend our home, that we then ran those points. And again, I accept, of course, those have cost consequences, but the full context must be looked at. And we say it's not good enough, therefore, just to say, well, you have the cost of the ones that you won on, and you have the cost of the ones that you won.
And you issued the proceedings during the currency of the term.
We did.
Yeah.
We did, and we got an injunction in order to stop them selling the properties. And that order is in the bundle. It's in the supplementary bundle, sorry. And it is tab 6, page 35 of the supplementary bundle. And we may come to that in due course. The second point we make about the issue-based cost order is that it entirely ignores the fact that my clients had made a series of offers to the first respondent, both before the proceedings were issued and shortly after the proceedings were issued, for payments of sums which were in excess of what the respondent ultimately would have been entitled to at that point. So, in other words, we were successful on all our offers. They weren't Part 36 offers, they were call-to-bank offers. But they were offers which there was no dispute about, that the judge was not only entitled to look at, but was actually required under the rules to look at any admissible offer. And those offers were dismissed by the judge, and we'll come to the judgment, as on the basis that, oh, such things are common in litigation. And they sounded not at all in the cost order. And one can see that because the cost order is purely, you won on these issues, you get your costs, they won on these issues, they get their costs. So it had no impact at all on the cost order. And yet if the respondents had accepted those offers, the litigation would never have been necessary in the first place. And the judge appears to have missed that point. And we say that's an injustice on our clients. And the third overarching point about the issue-based cost order is, and we'll come to the rules, judges can make issue-based cost orders, of course they can, that's one of the options they have, but they're discouraged to by the rules, and they're encouraged instead to make percentage cost orders. And the judge didn't do that, and as I've already said, he didn't canvass it first in order to get submissions as to whether that would be a good idea. The main reason for why that is so, perhaps the only reason why that is so, is that purely issue-based cost orders are deeply impractical when one comes to assessment of costs. Because in relation to almost every single item, whether it's a letter, whether it's the trial, whatever, the potential for arguments as to whether it was this issue or that issue, or in fact both, but was it 60% that issue, whether it was 40% that issue, are legion. And it results often in internecine warfare on detailed assessment. And a poor cost judge has got to grapple with this. That has to be contrasted with a percentage-based cost order where we simply have all our costs assessed and then we get chopped at the end by a percentage. So none of these issues arise. And we say that that's another reason why the judge shouldn't have gone down that road. Can I then come to how this litigation came about, and start in the supplementary bundle with tab 4 and the default letter on the 8th of September 2020. So Gunnar Cook were representing the first respondent, and they wrote on the 8th of September 2020, so that's a month after the monies were drawn down, giving notice under that the borrower is currently in breach of paragraphs 10 2k of the facility agreement by its occupation of the property at 71 Hamilton Road. And then next paragraph, in accordance with paragraph 12.2b, the breach identified as a material breach of covenant and therefore constitutes an event of default under the facility agreement. As a result of the event of default, and in accordance with paragraph 6.6 of the facility agreement, the lender will commence charging default interest on the outstanding sum as at Monday 7th of September 2020 until such time as the breach is remedied. And we know that that default interest was about 60% per annum, when it's 4% per month compounded. It works out at 60% per annum. So it's obviously a very large sum on a loaned amount of 1.881 million. The lender fully reserves its right to issue, demand and enforce any of its security and or commence legal proceedings against the borrower if the breach is not remedied before the 8th of October 2020. And then it mentions fees that have been added to the account. That was then followed by the demand notice, which appears at tab 5, page 33. And the it refers in the background to the facility agreement, and clause 11H, the borrower warranted that neither it nor any related persons would occupy the property. Lender became aware that a related person did occupy the property. One of the oddities about this case was that the borrower was in fact CEK, the third, and so related persons was, not strictly related to it, but I think effectively, the judge has taken the view that it was clear what it meant. And related persons mean related to Mr. and Mrs. Houssein. It said that the breach was initially remedied but has since reoccurred. In accordance with 12.2h, the lender is now entitled under clause 12 to demand immediate repayment of the loan together with all interest, fees and any commission. So there's the demand of payment at 3.1. Immediately pay the sums of 1.818518.27, that being the facility plus all outstanding interest, fees and other amounts due by the borrower to the lender as at the 3rd of November 2020. And that interest continues to accrue at a rate, total daily interest of £2,473.64. Right to enforce at paragraph 4. Should no payment be forthcoming, the lender fully reserves its right to enforce all or any of its security over the property and or commence legal proceedings against the borrower without further notification. And 5, if the borrower is not able to make the payment, sign the box below. So that obviously would have been a pretty frightening letter to receive. It's clear that the property was threatened. It happened to be that Mr. Houssein was not a well man and he died the following month of COVID-19. On the 24th of November 2020, that sum not having been paid, the second respondents were appointed as receivers in relation to the family home. And then on the 20th...
Not just the family home, all the other...
Just the family home at that point, but they were then appointed in relation to the buy-to-let properties.
And that date was? Sorry?
24th of November 2020.
Thank you.
Both date, same date for both?
No, so the 11th of March 2021
For the second, for the
for the
buy-to-let.
other, for the buy-to-let properties. So then, and on the 27th of November 2020, it's the document is not in the bundle, but it is referenced in the bundle. The receivers gave notice to vacate the property, that's 71 Hamilton Road, by the 18th of January 2021, failing which it was intended to put the property into an auction for sale to take place on the 18th of January 2021.
If you can give me those dates. On the 27th of November,
Yes.
receivers gave notice to that they should vacate number 71
Yes,
by,
by the 18th of January.
thank you. And when was the date that we put in the...
I think it was the 18th of January as well, and it if one goes in that bundle to tab 16.1, this is actually the next document I'm going to. At page, starting at page 297. There is a letter sent by email from Mr. Mark Britton, who is counsel, who was, as it appears at the start of that letter, was instructed on a direct access basis by my clients. Mr. Ali Houssein had just died, I think, at the end of the previous year. And he wrote on their behalf on the 13th of January 2021 a fairly detailed letter setting out the background in relation to the facility letter at paragraph 1 and at paragraph 9 he says this: in any event and prior to completion on the 23rd of July 2020 the broker sent an email to my client's son Houssein about, and the email said, and the judge deals with this in his judgment: "Hi Hussein, the lender's solicitors is preparing the security documents, but there is some confusion as to your parents' home address. Where do they live? As the proof of address documents show their home address is 71 Hamilton Road, but this is one of the security addresses, ? Kind regards." And Hussein replies: "Morning media, 71 Hamilton Road is correct. This is his residential home. Kind regards, Mr. and Mrs. Hussein." And at paragraph 11 he says, "At all material times CEK was aware that the property was the residential address of my client and her husband." He then sets out the breach, and he says at paragraph 16, the alleged breach, and at paragraph 16 he says why there was no breach. Paragraph 24 says, "Furthermore, LCL were at all material times aware that my client and her husband resided at the property." And then paragraph 26, he says this: "By way of a letter dated," this is what I was referring to, my lady, earlier, "by way of a letter dated 27th of November 2020, the second respondents gave my client notice that on the 26th of November 2020 they had been appointed by LCL as fixed charge receivers. My client has been asked to vacate the property by the 18th of January, failing which it is intended to put the property into an auction for sale taking place on the 18th of February. Sorry, it's the 18th of February is the auction for sale planned."
It really doesn't matter for this purpose. So I
Yes.
don't quite follow the sense of that. So if they did vacate by the 18th of January, the property wouldn't be sold.
Yeah, I'm assuming it means that once they'd vacated, it would be put into the auction. but I agree with Ronald, yes. He then goes on what my client wants at paragraph 30. Paragraph 30, my client requires your confirmation that you agree that she does not have to give up possession of the property until the dispute raised in this letter is resolved, and further that no attempts will be made to place the property into any auction for sale. She reserves her right for further legal challenges. And paragraph 32, if that's assurances are not given, then she will consider making an application for an injunction. And then, carrying on this chronology, my instructing sisters, Hugh Cartwright and Armin, were then instructed, and their first letter is at tab 16.2, page 304. And in relation to that, if I can take that letter fairly briefly, it summarises the allegations against Mrs. Houssein. It refers to the facility letter, and then on page 305, halfway down, it suggests that the facility letter is unenforceable and takes various points in relation to that. And then on the last page, 306, it says, second paragraph, entirely without prejudice to our client's primary contention stated above, if the facility letter is held to be valid, which is denied, one, there's been no breach, and therefore LCO is not able to call an event of default. The appointment of the receivers is therefore unlawful, and we would mention that the default interest stipulated in clause 6.6 of 4% a month compounded is so high as to amount to penalty. And then we start to get a series of offers from Hugh Cartwright and Armin on behalf of my clients. So the next document at 307, if one recalls that the total amount repayable on the loan was 1,881,000, but that was at the 7th of August 2021, and had, as my learned friend Mr. Cowan outlined, had included interest. Then on the 16th of March 2021, Mr. Armin, on behalf of my clients, made an offer that what my client is offering is £1.2 million by the middle of April 2021, and a further £650,000 again by the middle of April 2021. In return, my client would expect discharge of all the securities, including for the avoidance of doubt 71 Hamilton Road, in favour of LCL, and a concessionary default interest rate to be agreed between the parties, which my client will pay. In the meantime, neither your client nor the receivers will take any further steps to dispose of the property as the subject of securities, and invites them to agree that offer. So that offer was a total of £1.85 million, which I think is common ground, is at the time that it was made more than they were entitled to if the full amount was paid at that time.
How does that fit with the earlier letter? The demand letter, wherever that was.
Yes.
Point one. No, demand letter was.
The demand letter is at tab 5, page 33.
So what figure did that give?
That had a figure of £1,818,518. That included some fees that they say they were entitled to as a result of the default, but that figure, of course, is less than the £1.85 million that was being offered in March.
But you had by then had another. I mean, it's going to be paid by April.
Yes.
So by then you've had 5.5 months.
Yes.
At. Yes. Does that work? I'm not quite sure. I mean, I don't really understand the figures. I mean, as has been pointed out to us, up front,
yes,
you pay interest for the whole year at the
Yes.
standard rate.
Yes.
When they make their demand on the 3rd of November, do they give credit for the fact that actually most of that interest won't have been?
I think that's right. They don't. No, sorry, they don't. They don't.
Because if not, you might think that there ought to be some credit for. I mean, I don't know how it does work
No,
contractually,
absolutely.
but you might think there ought to be some credit for the fact that you've already paid standard interest through to
Yes.
late the following year.
Yes.
Um,
Exactly. Of course, there was the dispute about whether there was default interest payable
Yes.
at this time. So when one compares the figures, obviously but
Yes.
ultimately what we compare for these purposes is the 1% rate, because there was in fact no default on the judge's findings.
Yes.
And on that basis, the figure of 1.85, and certainly we can do more maths on it, but it's never been disputed
No.
that this was a better offer than they got at the end.
Yes.
And there are then
What they got at the end, but on the basis that if the
Oh,
clock
sorry.
had been
imprecise,
stopped
my lady. You're quite right. What they
At the
would
same
have got
time.
at that same time,
Yeah.
exactly right. That's the right comparison, because of course interest was continually accruing at whatever rate, obviously, but on the judge's findings at 1% month. So that was the 16th of March, an offer of 1.85 million payable by the middle of April. Then on the 23rd of March, there was a further offer in open correspondence. So this wasn't without prejudice, save as to costs. It's dated 23rd of March at page 309, tab 16.4. It notes in the first main paragraph, it is quite apparent even at this stage there will be a dispute between the respective clients as to the level of the default interest. And then it says, nevertheless, missing out the paragraph in between, nevertheless, in the interest of narrowing the issues in accordance with the overriding objective, our client's proposal will be set out in open correspondence as follows. Loan of £1.2 million will be secured over 3 properties, that's 199, 201 and 203 down Hills Way, and LCL will be required to release its charges in order to receive the funds. A further loan of £650,000 will be made, but a third-party charge over 71 Hamilton Road is required, so LCL will be required to release its charge over that property. Once the £1.85 million has been paid to LCL, the only outstanding issue will be the issue of the receiver's cost and the default interest rate claimed by LCL. These are disputed sums, the complaints made by our clients have been canvassed in previous correspondence. The net effect will be that our clients will be paying the redemption amount almost 6 months early. In addition, the 2 remaining buy-to-let properties valued at in excess of 1.1 million, and in respect of which you've seen mortgage offers of £800,000, will be retained by your client under the terms specified below. And then our paragraph 4, our client's proposal in relation to the 2 remaining buy-to-let properties are as follows. And so LCL were entitled to maintain its security over the 2 remaining buy-to-let properties. And the issue that our clients wish to litigate can then be discrete litigation as to whether your client is entitled to the default interest. And our client will provide an undertaking to issue proceedings within 28 days of the payment of 1.85 million. Your client will provide an undertaking that neither they nor the receivers will take any steps to sell the properties. And then if our client's application is unsuccessful, further time will be allowed to pay. The sum in question at F is about £500,000. And it's pointed out that your client will receive £1.85 million and still have sufficient security in relation to its claim to be entitled to the default interest and costs which are disputed. So again, an offer of £1.85 million on very specific terms, but providing security and suggesting that there would be a single litigated issue about the default interest. Then matters moved on. The next letter in the bundle is the 7th of April 2021 at tab 16.5, page 311. There's some debate in the first three paragraphs about various issues, but there is then at paragraph 4, nevertheless, in the interest of resolving matters without recourse to legal proceedings, we make the following proposals which our clients believe will meet reasonable concerns. Again, at 4.1, there's an offer of 1.85 that we understand that our clients should be able to make in a payment of £1.85 million by the 21st of April. Please confirm this is acceptable. Upon receipt of the sums, your clients will provide executed discharges in relation to 3 buy-to-let properties in 71 Hamilton Road. And then at paragraph 4.4, Mr. Ali Hussein's probate will be available in the near future, potentially by July. On receipt of the probate, Mrs. Houssein will complete the refinancing of those 2 properties as quickly as possible and pay LCL with the sum of £350,000 in return for the executed discharges. So that is an offer to pay a total, I think, of £2.2 million, with £1.85 million being paid immediately and the £350,000 payable upon probate being granted. And next offer is at tab 16.6, page 313. The next day from Mr. Amin. This is actually not an offer. This is, as you can see in the first paragraph, I thought I could float a potential solution which could save my clients any more money without any specific instructions from my client. And they suggest a payment of 1.2 million and discharge of 3 of the properties, then they say a further £800,000, paragraph 2, will be payable a couple of weeks thereafter. So that takes us to 2 million, and then at paragraph 3 that leaves a balance of 200,000. And there's a proposal in relation to payment of the £200,000. All this would occur before 9th of April 2021, failing which your client can proceed
August.
with
You said April.
Sorry, August. Sorry, 9th of August 2021, failing which your client can proceed with enforcing its securities.
And that is just the term date, isn't it?
That's the term date, yes. There is then a further email, the 11th of May. I should interrupt that to say that the interim injunction was obtained the day after this email, and we'll go to that. But the 11th of May at 16.7, page 314, I have taken instructions. My client is prepared to offer. So the previous one was floating an idea. This was an offer, £2 million, in full and final settlement of all the claims that my client has got. My client will instruct her conveyancing solicitors to proceed with the remortgaging of 3 buy-to-let properties, and your client will provide the appropriate discharges to let against a payment of £1.2 million. The remaining £800,000 will be paid again before the 9th of August, so the repayment date. Tomorrow's application, that's for the injunction, will be dismissed with no orders as to costs. And then there's undertakings in relation to discharging the receivers. That, of course, is not accepted. None of these offers are accepted, and the interim injunction is obtained at tab 6 in this bundle, page 35. The proceedings have already been issued at this stage. They were issued in late April. And then the injunction was granted by Mrs. Justice Falk on the 12th of May. And that injunction is that the defendant's paragraph 1 must not place any additional security. In the case of the first defendant, appoint any further receivers. In the case of the second defendant, exercise any powers of receivership. Demand vacant possession of any properties, or sell or attempt to sell or market sell any of the properties. So, I mean, obviously, the first respondent's position at that time was not to undertake to do that, so it was necessary to get the injunction. So then, that 11th of May, then there was a gap until, and I'm happy to say that we're coming to an end of this correspondence, but at 16.8 at page 316, there has in the meantime been a payment of £1.2 million. On the 28th of May 2021. That was a result, I think, of properties being sold. Remortgaged, sorry. Properties were remortgaged, and £1.2 million was paid on the 28th of May 2021.
And when you see properties remortgaged, you mean properties over which the lender already had a charge?
Yes.
So they must have facilitated that.
Yes, they did. Yes. And then, so on the 14th of October, there's another attempt by our side to settle the matter. Another email from Mr. Amini, and at page 316. The second paragraph, essentially LCL are looking for £2,050,000 in relation to a loan for 1.6 million, approximately, without giving any credit for the interest collected in advance in respect to the full loan when the 1.2 million was offered in May. My clients will pay 900,000 within 28 days of
700,000?
Sorry, 700,000, sorry. Yes, 700,000 within 28 days and a further 100,000 in 12 months' time. So that would take the total up to £2 million because 1.2 million had already been paid.
Sorry, just to understand. So LCL is looking for 2,050,000.
Yes, that's including the default interest.
Yes,
And
I see.
is that over and above the 1.2 you'd already been paid?
No, I think
Includes it.
I think it includes it.
So really, the difference isn't very much.
The difference isn't very much, but of course the last £100,000 isn't being paid for 12 months.
Okay. Well,
It's £50,000, isn't it? That's all.
Yeah,
this is after the injunction,
this is after the injunction, exactly.
and what else had happened in the proceedings? Just trying to work out
So,
how long ago that was. And
so the in terms of the proceedings, the particulars of claim was 27th of May 2021, and the defence was 9th of July 2021. And
so at this point, you were under £100,000 apart.
yeah,
Save that you, as you say, presumably couldn't raise the extra £100,000 for a
That's
period.
Over which period there would be further interest accruing
yes,
at whatever rate was applicable.
yes. Or not, as the case may be, in relation to Mr. Cowan's argument. Yes,
And in any event, the 2,050,000 includes the default interest,
exactly.
which depended on the event of default
Being-
happening during the term.
Yes, and default interest being enforceable.
Yeah.
In the
Which-
background, are there other things going on? I know the last paragraph of this email,
Yes.
which is that we're not concerned with all that, are we?
Well, we'll come back to that. I think your lordship is absolutely right. That was pretty key at the trial. These were the photographs of the inspection on the 29th of
Yes.
July.
So yeah.
That's all about the waiver issue. Yeah.
That's all about the waiver, is
Yeah.
exactly. Yes.
So on a completely separate matter.
Yes.
Not that separate.
No.
But it is separate in the sense that for this purpose, you're accepting the debt.
Yes, we are exactly, and we were. So you have a number of different offers over that period from March until that's October. Sorry, there is one more on the 1st of November, page 318, tab 16.9. And this relates to the difficulties of raising the money. So at 318, second paragraph from Hugh Cartwright, I mean, the best our clients can offer is a payment of £700,000 as soon as the remortgaging of the two buy-to-let properties is completed, and £100,000 secured for a period of 12 months. Our clients are very reluctant to amend this offer or to increase it simply because they believe that no credit has been given to them for the advance payment of 1.2 million and the wholly unreasonable behaviour adopted by LCL when Mr. Houssein passed away. So again, that's a total of 2 million, but the last 100,000 wouldn't be paid for 12 months, and it would be unsecured. On my calculation, that's total of 7 offers that were made over that period. 2 at 1.85 million, 3 at 2 million, and 2 at 2.2 million. And they were all effectively beaten by the end result, viewing them at their time in terms of what it was worth.
When you make that submission, what's the ballpark figure for the end result after trial and the consequential judgment?
So, yes, the order at the core bundle tab 8.
Three little
Yes,
lines.
it's little.
Eight,
It's little.
eight,
it's paragraph
811,000.
Yes, 3.7 is the total amount payable at the end of the contract term was just less than £620.
Sorry, so say it again.
Sorry, so paragraph 3, subparagraph 7. By consent, and this is consent after trial, the total amount payable by the third claimant to the first defendant at the end of the contract term of the facility agreement was £629,991.
And then subparagraph 9.
Yes.
So we add that
The
on.
amount of interest added on so it's a total of 811,000.
So at the end of the term, by the end of the term, you've paid 1.2 million early, in fact,
Yes.
in May.
Yeah.
And so if you add 1.2, you get to 1.829, which
Yes.
is indeed less than the figures you've been referring us to.
Yes.
But if we go forward on the judge's basis another 2 years,
Yes.
we add on another 181,000.
Yes.
So that takes you to about 2 million, does it?
Yes, it takes just over 2 million, isn't it?
Yeah.
2,011,000.
So that was beaten, would have been beaten, that figure would be beaten by your later offers.
Yes. Yes, because the later offers were made in October, November 2021, whereas the judgment was 2023. And had been acquiring interest at the simple rate on the judge's finding throughout that time, 2% per month.
And had they accepted the offers, any of the offers, they wouldn't have incurred the cost of which on the issues they lost and on the issues they.
That's absolutely right. Yes, that's our case. Absolutely. and we say sort of two main things arise from that. Firstly, taking your lordship's point, all the costs from that point onwards wouldn't have been incurred. And secondly, the fact that we were accepting liability for the principal sum throughout those offers demonstrates that the real dividing line between the parties was whether there was an event of default and whether default interest was payable. And that's why this litigation came about, because we had to issue proceedings and pursue those proceedings because they were taking steps to enforce their securities on the basis of the event of default. And when one comes to consider who is the successful party overall, we say it must be us, because we were successful in that endeavour. We saved the property, we avoided the liability for default interest. And all these offers were all in relation to that, were made on that basis and were refused by LCL.
I can't remember. The judge specifically says, does he, that it isn't appropriate to work out who the successful party was?
He says, I mean, we can come to the judgment.
Yes, don't worry, we'll get there in the end.
We will come to it. Effectively, he says, well, I mean, I'm loath to paraphrase.
No, get to it when you're ready.
It's dealt with briefly. Effectively, he says he doesn't think there's an outright winner in this case, and our point is, outright is a complete, comprehensive winner, and of course we accept that there wasn't a complete and comprehensive winner because we chose to run with these arguments which we failed on as well.
To what extent is his evaluation of that influenced by his findings on honesty?
There is an element of a plague be on both your houses in relation to that.
That phrase is going from my mind.
Yes.
I let you use it first.
There is an element.
You kindly have.
I mean, the normal answer to that is no order for costs. That's the usual answer. Well, I just think you've all conducted yourselves horribly. You've all caused all these problems. No order for costs. Go away. He didn't do that. He chose to separate out the issues. But what we say in relation to the dishonesty, obviously it's a point that I have to deal with because he made adverse findings against Houssein, and I'll come to those. The litigation was caused, as I've said, by the first respondent alleging an event of default and putting the properties at risk, threatening the properties. And that arises from the first respondent's dishonesty because their officer, Mr. Stylianides, had concocted photographs. Well, not concocted photographs, that goes too far. He produced photographs with the intention of misleading to suggest that they were not in occupation when he well knew that they were. And if LCL had been aware, if LCL had taken that on board, and clearly the evidence from Mr. Theonopoulos, who was the credit manager, was that he was totally unaware of that. So it was limited to Mr. Stylianides. But LCL are fixed with his knowledge. They never would have gone down that road of alleging a default. And so their dishonesty infects the entire reason that the claim was brought. Now, the dishonesty of Houssein was that at some point he collaborated or cooperated with that scheme of pretending that they weren't living there and assisted with it. That was one element of his dishonesty. But it's their scheme, and the litigation was caused by them going down that road. So we say that, of course, it's a relevant factor that he found that Houssein was dishonest, but it didn't cause the action. The action was caused by the allegation of an event of default.
But does the dishonest collaboration, to use your word, by Hussein undermine your assertion that the claimants effectively won?
Well, we say not. We say this is a case where you have to analyse it to see, is there an overall winner? And we accept that in certain types of litigation and on certain facts, it's possible to say, actually, there's no overall winner here. And that is something that is open to a judge. Say, well, actually, I think it's just honours even, score draw, or whatever. But we say the judge went wrong because we were the overall winner. We weren't a complete and comprehensive outright winner in his terms. Clearly we weren't. But the litigation resulted from the allegation of an event of default. It never would have resulted otherwise. And that allegation was incorrect and was in fact founded on dishonesty on the part of LCL in the form of Mr. Stylianides. And so overall, considering what this litigation was about, considering the offers, obviously, which are highly relevant, we say, that we made that could have avoided this, which were on the basis we have to be liable for the principal side.
Yes, the dishonesty. It may be the dishonesty you would say is relevant to the who won issue. You don't accept that bit.
No, I don't.
Even if it is, it's not relevant to the offer point, because
No.
the offer point.
Absolutely, they
dishonesty
could have
cuts
accepted any of those
cuts
offers.
neither way. Cuts
Yeah,
either-
exactly.
is irrelevant. Yeah,
Yes,
on
Yes.
your case.
yes.
Thank you.
So the effect of the dishonesty, we say, is different. I don't shy away from the fact that there were some very adverse findings about Hussein, but it wasn't the reason the litigation happened.
Well, putting another gloss on it, you might say the whole business about whether or not there was occupation of number 71 Hamilton Road was at the very heart of the issue about whether there was default interest, whether there was event of default.
Yes.
And Mr. Hussein was actively involved in that very issue because he was colluding from the start in relation to at least putting it forwards on a false basis that there was not occupation. And so he always knew, perhaps, that this might become an issue. Who knows? I'm not saying anyone knows or not, but that is central to the whole matter, and he was directly involved with it.
Yes, I'm sure that might be said against me. On the judge's findings, he wasn't involved from the start, or that there's no finding that he was involved from the start. He became aware at some point that occupation was a problem, and he assisted them in their scheme, Mr. Stylianides and Mr. Leondaris, who was the broker, their scheme to come up with a false account that they weren't living there. But he wasn't. But the judge doesn't find he was involved in that from the start. He became aware of it and then assisted. So yes, of course, that is a central issue. But again, I go back to the fact the claim was all about an event of default, and LCL should never have brought that claim because they knew that they were living there.
And it's paragraph 17 where the consequential judgment is, where you say the judge went wrong when he says,
Yes.
I don't view either party as an outright winner.
Yes, that's right. That's the extent of his analysis of it.
So one question that you're obviously going to take us to some of the authorities.
Yes.
I haven't been back through them. I do remember generally you're supposed to try to work out who the successful party is.
Yes.
And so I suppose in that particular respect, you say he didn't actually ask the right question because he was looking for an outright winner when he should have been looking to see who overall should be seen as a successful party.
Exactly. That's exactly what we say. And he says, then later on in paragraph 17, accordingly, I do not believe that a discount for the recoverability of costs would reflect success and failure in this case. Well, why not? The issues on which the parties succeeded were distinct, not subparts of a larger issue. But why does that mean that he's not able to evaluate firstly, who was the overall successful party, and secondly, what kind of discount should be applied for the fact that they didn't win on every issue?
So sorry, I wasn't keeping up. So
Sorry.
we've dealt with outright winner. Then he accepts the submission that your clients sought to escape their liabilities.
Yes.
Well,
And then...
if it's a matter of pleading, I suppose that's true, given the statutory defences.
Yes.
Certainly not true on the basis of the offers.
No, that's right.
Had the statutory defences succeeded and ignoring the offers, would you have escaped all liability, or would you still have had a liability to repay the money that you'd received?
I think we probably would have escaped all liabilities. No. Right. So we'd repay the principal, no interest.
Yes, I see.
Yes.
So it isn't actually to say that they wouldn't be right to say that they were trying to escape, even on the pleadings, all their liabilities, but there would be, on the pleadings, an attempt to escape liability for interest.
For any interest at all.
Yeah.
And he appeared, so that then the next sentence, after saying equally the defendants sought a significant sum in default interest, and again were unsuccessful. Accordingly, I do not believe that a discount for the recoverability of costs would reflect success and failure in this case. We say that just doesn't follow. Why is that so? Judges after trials often have to deal with the fact that, you know, there's dicta that suggests that it's more common than not that a successful party doesn't win on every single issue. So why does it follow from the fact that we succeeded on those issues and they succeeded on those other issues? Accordingly, I do not believe that a discount for recoverability of costs would reflect success and failure. That we say is him backing out of making that evaluative assessment, which is absolutely crucial on costs. He appears to say just because one party's won on some issues and one party's won on other issues, therefore I can't come up with a percentage-based order in favour of one or the other. And the fact that the issues were distinct, not subparts of a larger issue, again, why does that mean that you can't come up with an evaluative assessment of who was the overall successful party, and secondly, what discount should that party have from their costs? My Lord, I note the time. I was going to come on to a new subject. Would this be a convenient moment?
Yes, I see my watch says it's almost 1 o'clock. That clock says it's 5 to 1.
I make it 3 minutes to 1.
If nobody thinks we're in time trouble, then we'll start again at 2 o'clock.
Thank you very much.
How are you doing that time?
So bad at estimating, to be honest.